Good afternoon, everyone, and welcome. We're pleased to have you with us. We have 4 cases on the docket, but I understand that an announcement has been or will be made. Would you tell you what? Would you call that case for me, Madam Clerk?
Betty Harris versus Williamson County et al.
All right, counsel may approach the podium.
Your Honor, may it please the court, Bryant Kroll. I'm pleased to announce that this case has been resolved. We withdraw our appeal, and I'll be filing that with a notice of withdrawal.
All right, and are you representing?
Your Honor, we represent the appellee.
Very good. All right, and we will prepare the order to officially dismiss and assess costs, but you'll need to file a notice or a motion to say that the appeal is withdrawn, and then we request that you do that within the next 2 business weeks. Is that acceptable?
Absolutely.
Very good. All right. Then that is the case of Harris versus Williamson County. All right. Thank you so much. All right. We now have 3 cases on the docket. And anybody else want to settle? Going once, going twice, okay. We will hear the cases in the order in which they appear on the docket. Each side has 15 minutes to argue. The appellant has the option of reserving up to 5 minutes for rebuttal. So when you come to the podium, after you've introduced yourself, let us know how much time to reserve, and the clock will be programmed accordingly. Are there any other announcements? Hearing none, call the first case.
In re Estate of Dewey Knight.
All right, good afternoon.
Good afternoon. May it please the court, my name is Miles Martindale, and I represent the appellant Dwight Etherly. It's my first time appearing before this court, and so I'd like to say that it's a great honor to be here today.
Well, we're pleased to have you here. We're normally pretty rough on rookies, and so you might want to tighten your shoelaces.
At this time, I'd like to reserve 2 minutes for rebuttal.
2 minutes, yes, sir.
The issue presented for appeal today is whether the trial court erred when it granted the movant's motion for summary judgment and held that the testator intended the language "all personal property and household goods and furniture located thereon" in paragraph 5th of the will meant to exclude certificates of deposit, savings bonds, cash, coins, and other financial instruments that were removed by the executor from 8 Watervale Lane, which my client inherited. Appellant Dwight Etherly's position is that the trial court erred when it granted movant's motion for summary judgment because the language of the will is unambiguous, and the phrase "all personal property" should be given its all-encompassing meaning because the relevant section of the will is devoid of any limiting language. Again, the issue on appeal here today is the probate court's order granting motion, the appellee's motion for summary judgment, and because this inquiry involves purely a question of law, the standard of review is de novo, and the appellate court shall afford no presumption of correctness to the probate court's determination. The purpose of a suit to construe a will is to ascertain and give effect to the testator's intention. The cardinal rule in construction of all wills is that the court shall seek to discover the intention of the testator and give effect to it unless it contravenes some rule of law or public policy. In gleaning the testator's intent, we look to the entire will. The testator's intent is to be determined from the particular words used in the will itself, not from what is supposed the testator intended. Tennessee has very little case law interpreting the meaning of all personal property in the context of a will. However, it does have one case that analyzed the phrase "all personal property" in the context of a will. In Cobb v. Stewart, which is a 1971 Supreme Court case for the state of Tennessee, the decedent left his estate to his wife Alice Cobb and brother B.W. Cobb. In his will, after specific bequest of personalty to his wife and realty to his wife and brother, the decedent included item 6, which is the basis of the lawsuit, and it said, I direct that all of my interest in any business or partnership which I may own at the time of my death and all personal property shall be sold and all of my debts paid from the proceeds. I will and bequeath 1/4 of the amount remaining after the payment of my debts to my wife, Alice Cobb. The remaining 3/4 shall be used by my executor hereinafter named in the purchase of real estate, the title to which real estate shall be taken in the name of my wife, Alice Cobb, for and during her natural life, and the remainder interest therein vested equally in the children of my brother, B.W. Cobb, namely B.W. Cobb Jr. and Lynn Cobb, and the children of my sister, Edna Earl Stewart, namely Elise Stewart and David Stewart. The appellee in Cobb argued that the personal property did not include cash and other financial accounts because they did not need to be sold. However, the Tennessee Supreme Court disagreed and held that cash, savings account, and other financial accounts are considered a part of all personal property. Moreover, the court held that the word all is inclusive and embraces all personal property unless accepted therefrom by descriptive words. In this case, paragraph 5th of the will devises real property located at 8 Waterville Lane to Dwight Etherly and specifically states, I devise, bequeath to Dwight Etherly all personal property and household goods and furniture located thereon. This language is not limiting, it's inclusive. The facts of this case are very similar to an Ohio case, Sandy v. Mahout, and I have included the citation in my brief. In Sandy, the court held that the testatrix's intent in a will which bequeathed all of my personal property and household goods to my niece could be interpreted as bequeathing all personal property, including intangible personal property. The court decided that a broad interpretation of personal property was appropriate, and more importantly, the use of all suggests that the testatrix intended to give all of her personal property, including intangible personal property, to her niece. The court noted that contrary to the rule of ejusdem generis, there is no enumeration or listing of things in the will. Instead, it contained a general term, personal property, and a more particular description, pointing out that a general term will not be reduced by a particular description when the description appears to be an example or a means for identifying the property further. Dwight Etherly acknowledged in his response to the motion for summary judgment at the trial court level that the language of the decedent's will differs slightly than the language in Sandy, but the reasoning is the same. The decedent did not enumerate specific items followed by a general term. Like Sandy, the decedent specifically chose a broad and general term followed by the word and to include an example. The decedent in no way meant to reduce the first term. The appellees have mischaracterized Mr. Etherly's position when they have stated previously that he believes that all personal property in a paragraph about a specific parcel was intended to simply include all personal property no matter where located. Appellant Dwight Etherly acknowledges that there is some limiting language where it says located thereon. So if it's not located on that property, it is not Dwight Etherly's position that he's entitled to that personal property, or if it's otherwise disposed of in the will.
What if an automobile title or a truck title was located in a drawer or in a box on the property?
Your Honor, it would be our position that would, unless it was disposed of otherwise in the will, that would be included.
Well, there is a residuary clause that disposes of everything else otherwise. But what about a certificate of deposit, which I believe is characterized as a chose in action? That this piece of paper itself is not the property, it's just an indication of ownership of property which is located at the bank. So how do you deal with a chose in action?
Your Honor, it's our position that the documentation was left there purposely, and it was intended to be encompassed under this clause of the will. And so it would be considered personal property under this, and it would not pass to the residuary clause because this would supersede that residuary clause.
Well, there were other, I think there are 9 or 10 articles or paragraphs in the will, and your client was a specific beneficiary of at least 3 of them. So the testator specifically identified some assets, personal property, that would go to him otherwise. So how does that factor in?
Your Honor, I think it goes towards the testator's overall intent, and that the majority of his estate was left to my client, and that the predominant purpose of the will was to convey that property to my client. And so we would submit that it's indicative of our interpretation of the will.
But he identified 8 beneficiaries of the residuary provision, and so he clearly intended for a handsome amount of his estate to go in different percentages to another 8 people, or your client was one of the 8.
And that's correct. And there was personal property that was located outside of this residence that was distributed through there. There were other stocks and things that, so it's not a situation where that residuary clause had no, it was unnecessary. There was other stuff that needed to be dealt with outside of the personal property located on 8 Watervale Lane. And so our position is that the CDs and the instruments that were physically located on 8 Watervale Lane were meant to go to my client and not the residuary clause.
The trial court considered the language the testator used. He bequeathed to your client all personal property and household goods and furniture located thereon, meaning on the residential property. But the trial court applied a Latin phrase, a doctrine, which I am going to butcher, ejusdem, E-J-U-S-D-E-M, generis. That means like kind. The items enumerated after the phrase all personal property are merely describing the type of property testator intended to bequeath. Otherwise, why would it be necessary for the testator to list specific items which were meant to restrict all personal property? Point being, the testator had already said you can have all personal property, but then the testator said, but I'm talking about furnishings and household goods and furniture. So the court considered that a limiting provision and of like kind restriction. How do you respond to that?
The way we would respond is that there is no limiting language, and that and is encompassing and not exclusive, and that the rule of ejusdem generis provides that there's been an enumeration of particular items followed by a sweeping clause, that it invokes that rule. And in here we have exactly the opposite. We have a general clause that then lists illustrative items, but it doesn't limit that initial all-encompassing clause whatsoever. And so it's our position that the ejusdem generis rule does not apply in this case. The appellees have cited 2 main cases in support of their position: In re Estate of Jackson and the Renz case. In re Estate of Jackson is a will construction case where the decedent disinherited family members because they were, quote, all financially secure. And in Section 5 of that will, he also allowed them to come and select personal property items, but expressly accepted and carved out securities and cash on hands or deposit. And so ultimately the court held that in applying the rule of ejusdem generis, the phrase other tangible personal property is limiting because it specifically says tangible personal property, and it doesn't include those those financial vehicles because they were specifically accepted. We don't have that here in this case. In Renz v. Lambert, the Court of Appeals was asked to determine whether stocks and bonds were included as a part of Section 4, which stated in the operative language in that case was the furnishings and other contents of said resident and storage facility located at a specific address. And in applying the rule of adjustum generis, the court declared that the bequest of furnishings and other contents does not include stocks and bonds found in there, because the general term contents is limited to terms of like kind. Here, it's not contents. It's a very general term followed by other illustrative terms. And so we would, again, say that that doesn't apply. In summary, Mr. Etherly states that, consistent with the case law cited in his brief, the term all personal property should be given its all-encompassing term and include those financial instruments. And the court should reverse the trial court's decision and grant summary judgment and hold that the phrase all personal property has the inclusive, not exclusive meaning.
All right, thank you, Mr. Martindale. We'll hear from you again on rebuttal. We'll now hear from the appellee. Good afternoon.
Good afternoon, Your Honor. May it please the court, I'm Guy Holloman of the Macon County Bar up in the 15th Judicial District. This is not my first appearance before this body, and I still remember the first one because Justice Martha Craig Daughtry sat right there, Justice Lyle Reed sat right here, and I don't remember the other one because it was enough taking them on.
Oh, my goodness. I feel sorry for that third judge.
You have a point. But anyway, appreciate the opportunity to argue the position of my client before the court today. I do represent the Appellees. There are indeed, as you mentioned, Judge Clement, 7 of those that are the nieces and nephews of the decedent, Dewey King Knight. That's what Mr. Knight goes by. You know, up in the country, you use all those names, so he was always known as Dewey King Knight. We asked the court today to affirm the trial court's decision because it's grounded in law. There is no disputed facts, and it's grounded in common sense. First thing I do want to address is that the trial judge made 3 decisions in his order concerning the construction of this will, and on appeal, the appellant has only listed 1 issue, and therefore, in our written brief, we did not address those other 2 issues because they were not listed as an issue on appeal as rules of appellate procedure require. And
The sole issue is what is intended to pass under paragraph 5th or item.
That's exactly right. The question is what did Dewey King Knight mean in his 5th paragraph? In the 5th paragraph, his will, when he says, "I leave my house and 20 acres to Dwight Etherly and the personal property and the household furnishings thereon, including," he added a word to household furnishings.
Yeah, I devise and bequeath to him all personal property and household goods and furniture located
yes.
thereon.
And so the question really comes down to that last part. What did he mean by that?
Is that language ambiguous in your opinion?
I have that question, Judge Davis, I have thought about and thought about and thought about. Is it ambiguous?
Because you know the next question.
The next question then is, do we look at extrinsic evidence to construe this will? And so that's the next logical question. And I will answer your question the way I finally answered my own question. If it was not ambiguous, why would we be in this position? Why would the executor, who is a lawyer that practiced for 50 years in Smith County, said, there's a dispute here? Why would they have said it doesn't mean what he said it means? And I'm not being trite about that, but I'm saying if a lawyer that had practiced probate law for 50 years says, I'm not sure what that means, then I think it is. It certainly raises to the level of ambiguous because of the various arguments that we later on make. It's ambiguous because what is property located thereon? Is it, as has already been discussed, those things that we normally associate with being personal property, i.e. household furnishings, the lawnmower out back, the lawn furniture out front, those sorts of things? Or is it the much more expanded view of it also includes that certificate of deposit or the bank account book that's laying in there, those sorts of things. So when you look at this case from that standpoint, the very questions that's raised by what it does mean and those things, then yes, the answer is, I believe it's self-proven that it is ambiguous because we're having to have this discussion and because of the various arguments made about what is property, what is not property. Now, so that does go to the very next question then. Can we look at extrinsic evidence apart from the four corners of this will to come to a determination of one issue? What was the intent of Dewey King Knight? And of course, that's what all of our case law says. We're here to seek the testator's intent, nothing more, nothing less. We have many rules of construction. We have many rules of evidence surrounding that. But the bottom line is for the court to glean that singular intent of his, which takes me to the extrinsic evidence, as it would. You have before you the affidavit filed in support of our motion for summary judgment of the late Jackie Beller.
He's the lawyer who drafted the will.
He is the lawyer who drafted the will. And of course, as noted, he was Mr. Dewey King Knight's client, or Mr. Dewey King Knight was his client. Mr. Beller assisted him with his probate planning. And in his affidavit, Mr. Beller says, I assisted him. We drafted this will. It was his intent that Dwight Etherly get that home place where I lived, that he get all the personal property located thereon. And he says that was supposed to be the tangible personal property. That was the intent of Dewey King Knight. And he said it was not his intent that Dwight Etherly received these other financial documents and such. Mr. Beller went on to say in his affidavit, which was interesting to me, he went on to say, to the extent that anybody reads that will and comes up with a different construction or meaning, it was error on my part. He said, it's on me. It was my language that I was trying to use to construct, to deliver Dewey King Knight's intent. I don't know if you all have noticed, but lawyers have a real hard time admitting mistakes. And, but nevertheless, Mr. Beller stepped up in this case and said, if that's how it's going to be interpreted, and I'm meaning the way the appellant say, then I made a mistake in using that language that way because that was not the intent of Mr. Dewey King Knight. So the point is, you all have an excellent source of information about the intent of Dewey King Knight when it comes to this paragraph 5th. And his testimony, as a statement of fact, is unrebutted, so there is no disputed question of fact concerning what he says the intent of Mr. Dewey King Knight is. Now, I do want to mention this in passing, that in the reply brief, the appellant now raises the issue that Mr. Beller's affidavit was not admissible. Well, I will point out again that, as I noted in my brief, that affidavit was not objected to in the main brief and not raised as an issue that the trial court erred in admitting the affidavit of Mr. Beller into evidence. And because that issue of admissibility of Mr. Beller's affidavit was not argued, briefed, it was therefore waived, and that's not really...
Was it argued at trial?
It was argued at trial. Now, I want to go back and say one more thing about that, though, before we leave that, Judge Davis. Though it was argued at trial, the basis for the objection was on the dead man statute. By definition, the dead man statute does not apply here by definition, because the dead man statute, as we all know, says that the testimony must lead to a judgment for or against.
To increase or decrease
Or
the
decrease
size of the estate.
Exactly.
As opposed to how to distribute the estate.
Exactly. And so that's the distinction. By its very definition, dead man statute does not apply here because of that definition, because it would not increase or decrease in any way whatever this court does. So I just point out that Mr. Beller's unrefuted testimony is just kind of speaking to you all as one lawyer to another, saying that I discussed what my client wanted, this was his intent, and here it is. And that this other items of property, i.e. the items of property that would go in the residuary estate, in fact, belong there to those 7 heirs. And I do want to mention this before we leave this singular issue, and that is Mr. Beller also pointed out in his affidavit that Dewey King Knight understood PODs and other such legal language that directed the ownership of those financial documents upon death, and pointed out that there were at least 2 financial documents where Mr. Etherly and one of the other named heirs actually were designated as PODs on those financial documents.
Pay on death.
Exactly. And so wouldn't that seem, or it does to me, it would seem somewhat incongruent that on one hand, he actually had those designated as such, and then on the other hand was just going to leave it up to paragraph 5 to say all property also means I want those folks to get, or get Mr. Etherly to get certain items.
To be clear, what you're saying is 2 of the pay on death financial instruments were in the lockbox. That's
Yes.
the subject of this section.
That's correct.
Thus, interpreting in this way wouldn't be necessary to bequeath those certificates of deposits or bank accounts because they have a contractual.
That's absolutely the position on that, and I think it's the logical or obvious place that you arrive. The next thing I want to mention as we walk through this is that when his statement said, and the property located thereon, and Judge Clements, you've already kind of touched on this, but I want to go just a little bit further in this. If you look at the UCC, the Uniform Commercial Code adopted in this state, it defines that a certificate deposit is located at the bank. That's where the deposit is made. A certificate of deposit is not located wherever that document manifesting your ownership is located. Likewise, there's case law in Tennessee that says also that the bank is the depository of your money, and that if you want to go receive your CD money, you have to go to the bank where it's located. By definition, to the extent that they maintain that any of the certificates of deposits, savings accounts, or checking accounts would pass to Mr. Etherly through paragraph 5 because they may have been a piece of paper located at the premises. By law, that's not the location of that property, by definition.
In other words, the personal property
Yes.
is located at the bank. The bank book, the CD, piece of paper indicating ownership may be in the lockbox, but the personal property of the money is at the bank.
Yes, and Judge Clement, the importance of that is because the will said, and the personal property located thereon. Had to be located at that premises. And to flip this argument around just a little bit, earlier you mentioned the vehicle, but I want us to think about a couple other things. From a public policy standpoint, if you took the strained version, or I really should say the construction, not the version, that the appellants are requested, My guess is, once this decision came out, there would probably be thousands of motions filed of mutual mistake throughout the courts of Tennessee, wanting to set aside final settlements and the order granting closing of the estate, simply because what's going to happen is, we all know that the way it normally works in practice is you have real estate, you have personal property, and you have cash. That's what we've always divided in probate matters. And
You
so,
know, if the only thing that bothers me about all this is that, you know, why do we put those little certificates that represent the money in the lockbox? Because they represent the money. You can't go get the money without that certificate or perhaps a court order or will that says you get it. So why isn't the fact that he gave all personal property to the appellant and certificates were there, why don't those certificates represent that money? Because that's like the key to the lockbox.
because of that phrase that said located thereon, and because the law is clear that CD is not, the money is not located on that property, and that paper just is a representation of ownership, no different, Judge Bennett, than if you had a will, if you had a deed to your real property, then you could have that deed to your real property sitting there in your lockbox, but that land may be down in Dixon County, and I can promise you that land is not located in your lockbox. And it's the same thing. It's not a stretch. It's
No,
really,
but I can't dispense of that land without that deed.
right? So I may be wrong, but I think you just made your own argument.
I
Said,
need
just
the
like I
deed.
can't go to the
So
bank.
the deed's at the house.
So if you're going to go with that, then we're going to say land can be located not where land is, but actually in the house too.
I'm not saying that. I'm
And maybe
saying
I missed the point.
The representation of ownership.
Okay.
You know, I can't help but go back to a case or two I litigated in which the Supreme Court told me that just because two people disagreed about what a document said doesn't mean that it's ambiguous.
Has to be a reasonable argument, a reasonable interpretation.
Yeah.
Because otherwise,
You know,
everything could be ambiguous if somebody just decided they didn't want to.
And maybe I overstated when I said there's ambiguity just because we're here. But then again, I think we see the ambiguity as we talk through these various arguments. Thank you all very
thank
much.
you.
I'll answer any more questions, but my time's over.
Thank you, Mr. Holloman. Mr. Martindale, your rebuttal.
Very briefly, I just wanted to point out a few things that I did mention in my reply brief, is that we did in fact object to the affidavit at the trial court level. It was in our cert reply to the motion for summary judgment, which is in the trial court record. And then also wanted to kind of follow up on what Your Honor was talking about in terms of the instrument being at least indicative of an intent to leave that financial instrument to my client. And although it's been made to be ambiguous, we do believe that the term, or phrase rather, all personal property is unambiguous. And we believe that even if the court decides that things like certificates of deposit don't apply here, there should certainly be a close examination of the items that were removed from the testator's estate that was left to my client with regard to cash, bonds, other things that do require physical possession. There's no way that I can claim cash if I don't have possession of it. And it certainly follows where it is possessed and located. So at this point, we would just restate that this court should reverse the trial court's decision to grant summary judgment and hold that the phrase all personal property is unambiguous and has the inclusive, not exclusive, plain meaning because the 5th paragraph contains no limiting language. Thank you.
All right, thank you, Mr. Martindale and Mr. Holloman, for your arguments. We'll take the matter under advisement. Call the next case, please.